for this webinar presentation. I am pleased to have the privilege to welcome you to our webinar today. Just a few reminders before we get started though. Our next meeting is the annual Medicare update on Wednesday, February 13th at Orlando's in Maryland Heights. The format has changed from previous years, so registration will begin at 7:30 a.m. and includes a breakfast. The meeting will end at 11 a.m. Ellen Barra, a senior analyst with Provider Outreach and Education Department with Wisconsin Physician Services Medicare, to discuss some of the new changes and implementations for Medicare. This will be a very timely and important discussion you won't want to miss. Today, I'm pleased to introduce our speaker. Diane S. Robben is a shareholder with Sandberg Phoenix and focuses her practice in the firm's health law practice group. Diane leads the firm's transactional and regulatory healthcare practice, devoting a significant amount of time advising hospitals, physicians, nursing homes, and other healthcare providers on a variety of issues to find practical solutions to complicated legal problems. She routinely advises healthcare providers on HIPAA matters, release of information, policy and procedure considerations, and general risk management issues. Furthermore, a substantial portion of Diane's work comprises representing hospitals and healthcare providers in Illinois and Missouri, defending cases involving wrongful death, catastrophic brain injuries, and a wide array of medical matters including emergency medicine, obstetrics, gynecologic, neonatology, post-surgical management, negligent credentialing, chiropractic care, and nursing negligence. She represents physicians, nurses, chiropractors, and other healthcare professionals in all phases of litigation, including mediation and trial. Diane earned her Juris Doctor, magna cum laude, from Southern Illinois University School of Law, Carbondale. She is licensed to practice in the state of Missouri and Illinois and before the United States District Court for the Eastern District of Missouri and the Southern District of Illinois. Diane has been a member of MGMA for 10 years and serves on the board of directors as the Vice President of Business Partners. But before I turn it over to you, Diane, I'd like to remind everyone that you are muted during this webinar to reduce background noise. However, we do strongly encourage you to use the all panelists selection in the chat box. It's a great way to share comments, examples, and questions with everyone on the webinar. We'll be monitoring the chat stream throughout the program, and at the end, as time allows, be able to answer a few questions. Please also remember that this webinar is being recorded. With that, I'm going to let Diane take over.
Good afternoon, everyone. I guess it's after 12, so it's technically afternoon. I wanted to welcome everyone to this webinar, and thank you for attending. I hope to provide you a little bit of a foundational background on some of the laws and regulations that pertain to release of medical records as well as retention and some other medical records tips and pitfalls, but also to give you some experience and practical tips from both a regulatory and a litigation perspective. As Melanie had indicated, feel free to post any questions you may have on the chat. I'll try to get to those as I'm going through if they're pertinent to the topic. Otherwise, we'll try to catch them at the end. So with that, let's go ahead and get started. So first of all, I put together some objectives of what we hope to cover today. I'm going to go over briefly the HIPAA high-tech business associate agreements and authorizations, release of records and charging for that, some perspectives on the legal health record, record keeping and risk management, including retention, destruction, and spoliation of evidence, some general documentation guidelines, and then some fun little anecdotal information on use of medical records at trial. So business associates under the HIPAA and HITECH Act, just to give you a little bit of a context, as most of you know, the HIPAA law itself was signed into law in 1996. We didn't get the final privacy rules until 2000, and then the final security rules in 2003. And most organizations thereafter implemented all of their HIPAA privacy and security provisions in 2003. We then went for 10 years without any real significant regulatory updates to that until January of 2013, when the high-tech omnibus final rule was signed into law. That became effective as far as a compliance date in September of 2013. So hopefully you all have been working diligently over the past 6 years, or I guess 5.5 years now, to get yourself in compliance with HIPAA and high-tech. The reason I wanted to give you a little bit of background with that, and I want to focus in on the expanded definition of business associates under the High-Tech Act. This is significant for our topic today, and I'll explain why. Under the Act, the definition of a business associate is one who, other than in the capacity of a member of a covered entity's workforce, so this is somebody other than someone within your practice's workforce, who creates, receives, maintains, or transmits PHI. This includes subcontractors of a business associate who then creates, receives, maintains, or transmits PHI on behalf of the business associate. What this applies to is if your organization, your physician practice, utilizes an outside copy service or vendor service to respond to requests for release of medical records, they are a business associate of your covered entity. One's status as a business associate is based on the roles and responsibilities of what that organization is doing, not whether or not they actually sign a business associate contract. Why this is important and the significant change from the prior HIPAA rules with the High-Tech Act in 2013 is there now is obligations that apply directly to all business associates within this expanded definition. So your vendors who process record requests, your organization as a physician's practice or a covered entity has to have a written business associate agreement with those vendors. But more importantly, those vendors are now directly responsible and potentially liable to the Office of Inspector General for breaches. Prior to this, if you contracted with the company to handle your records requests and they did something by improperly disclosing information or failed to disclose things in a timely manner, it still was just the covered entity who could be liable. Now the business associate also can be directly liable. So subcontractors, this is a visual depiction to show you how it is that you need to make sure you have these business associate agreements in place. So each party in the chain needs a BAA, which is a business associate agreement, for satisfactory assurances of privacy and security protections from a direct contractor. So to the left, you have your covered entity, which would be your physician's practice or hospital or other healthcare provider. If they contract or enter into an agreement with an organization where they're going to be providing PHI to that organization to perform a service on their behalf, such as a records copying company, they need to have a written agreement. If that company then has some type of billing organization or some subcontractor, a photo company or a storage facility that they subcontract with, they then need a business associate agreement going down the chain. The reason those documents are important is not only to ensure everyone is agreeing to be in compliance with the HIPAA and high-tech regulations, but also to ensure that there is strong indemnification language contained within those. Like I said, one of the key things to understand as a medical practice is that if you enter into a contract with a vendor company to handle your requests for information to do that, I don't want you to be misled in thinking that you're contracting away any potential liability. That vendor company is exposing itself to potential liability if there is some type of wrongful production or breach of the information, but the covered entity still remains liable. So both parties are now potentially liable to the Office of Inspector General. So some things to keep in mind with that in terms of a practical tip is that it is important, hopefully you can appreciate this, to make sure you know who it is that you're associating with. So if you do enter into a contract with one of the outside copying companies that will respond to your requests, make sure you do your due diligence and investigate them, get referrals from others that have utilized them. And then once you're in such an arrangement, make sure that you're doing regular auditing of their work that they're doing on your behalf You're going to want to randomly do a chart processing review to see if they're charging the fees in accordance with the statutory regulations, that they are timely responding to requests, and that the scope of the records that are being produced includes the entire chart, and that there aren't any errant records in there of other patients where you could have a potential breach. So just make sure that you're keeping an eye on who it is that you're entrusting your organization's PHI with. So some things with regard to record keeping and risk management. As most of you would understand, healthcare providers have a duty to create medical records. I mean, that's pretty much a given. Let me just, real quick question somebody had asked, what about a vendor that supplies medical equipment? If a vendor is going to be supplying medical equipment to the organization and simply just providing the equipment, and the practice is not sending confidential protected health information, PHI, back to that vendor, then you would be okay in not having a business associated agreement because they're simply selling equipment. But if PHI is going to be transmitted back to that vendor for them to perform a service with that information on your behalf, you're going to want to have a business associate agreement with them. So good question. All right, back to duty to create medical records. This arises through statutory obligations. Obviously, the basic part of that is making sure you have a record of the treatment that's provided. You know, the litigating lawyer in me wants to make sure you have everything documented, I's dotted and T's crossed. So you want to have a complete record of the treatment that is provided. It creates not only historical information for your providers and going forward, but is also evidence to be used at trial in the event of a malpractice claim. So the complexity with this is the fact that we have many different forms of documentation in medical records as technology continues to evolve. Some practices may be entirely still on paper, and they're holding out and going to do it until they no longer can. Others have shifted entirely to electronic medical records, and then others have a hybrid between the two. All of this adds to the complexity and the difficulties in complying with the regulations as far as producing medical records and responding to requests. So one of the things that I have documented within my presentation is talking about the legal health record. And this is a term of art that you'll see within some of the statutes and regulations, but it's also out there in secondary sources that provide guidance on what needs to be produced when responding to requests for records. So what is the legal health record? It is, for a medical practice, the official business record of the healthcare facility that is maintained as a patient's medical record. So it's easy to think about the treatment notes and the documentation by your physicians and nurses of diagnostic findings or vital signs. But you start getting into some of the ancillary things, and it becomes a little bit more murky as far as what the actual legal health record is. So where you can come to find some guidance on that is to look at definitions and guidelines from patient care information, medical staff, legal counsel, community standards of care, state and federal regulations, trade associations such as the American Health Information Management Association, third-party payers. All of these can provide some guidance in terms of what truly needs to be within your organization's legal health record. When you have an electronic medical record, this becomes much more complicated because you now have additional information through audit trails and metadata within the system that may not technically be part of your legal health record, but it's certainly information that's available. And savvy plaintiffs' lawyers in malpractice cases have started to ask for more of that. So what is actually included within the legal health record? Well, the important part of this is that it needs to be specific to your organization. I would recommend that as part of your compliance documentations and manuals that you have a written definition of what you have included within the legal health record so that you're applying a consistent definition across your organization and your practices and policies. Anything with individually identifiable data that is stored in any medium and is collected and directly used in documenting healthcare or the health status is technically what is part of your legal health record. And once again, make sure you have this defined within policies and procedures. So some guidance out of the American Health Information Management. I didn't list all of this. You can go to their website and find it. But your typical things such as history and physicals, discharge summaries, progress notes within a physician's practice. You're going to have your vital signs. You would likely have a list of problems that may continue throughout, your prescriptions, your referrals, any of your direct patient information that has patient documentation on there should be part of your legal health record. But you also need to make sure that you're not just looking to the paper chart or just the EMR portion of it that has the medical documentation, but make sure you're considering other various mediums that may become part of your legal health record. For instance, if you have an electronic medical record, I would hope that you have some downtime backup documentation available so that if the EMR goes down, you continue to see patients. So those of you that have transitioned to full EMRs hopefully still have some of those older progress notes so that you can make some documentations if need be. Likewise, if you have any type of diagnostic or imaging that is done within your medical practice, that's also going to be part of the legal health record. So your hybrid charts, make sure you're considering both paper and electronic, whether or not those are stored entirely on paper or scanned in electronic format. So it's going to take some time to sit down and make sure that you have a definition of the legal health record that matches how your practice is currently maintaining things. And don't forget, like I said, scanning certain records that may be going into the system, such as the informed consent documentation, referral forms, prescription forms if you're not doing e-prescribing, and any type of other documentation that the patient may be filling out. And like I said, if you look at the American Health Information Management Guidelines, it provides some other guidance on that to provide some greater guidance. So another place we can look is to the Missouri statutes, and the Missouri state law indicates following must be part of a patient's medical record. Quite honestly, this doesn't provide a whole lot of meat to it, but it's what we have within the Missouri statutes, and I think this is pretty straightforward. Patient identifying information, including name, address, birth date, telephone number, the date the patient was seen, current status of the patient, including the reason for their visit, their physical observation findings, assessment and clinical impression or diagnosis, plan for care and treatment, including medications. This also would include any consultations and diagnostic tests that are ordered by the provider, and then informed consent. This is the Missouri statute that requires what must be part of a patient's medical record. So pretty straightforward that you would have all of these things in your medical record, but important to make sure that your written policies include all of this. So out of these things, most of this, if you're using an EMR, would be electronically entered. Your informed consent, if you're still having that signed on paper, you want to make sure that that is scanned in the link so that it becomes part of the official chart. So things that are typically not part of the legal health record, and these are things that you typically would not be sending out in response to requests for records, whether it's through authorization or subpoena or deposition, as we're going to discuss in just a little bit. Any type of peer review, whether or not you're part of a greater organization that may be doing some review, or you have some informal review that's done within your medical practice. If physicians or nurses are doing any type of review of a particular patient chart, any documentation that's generated out of that should not be kept in with the patient's medical record. The metadata, I would suggest that your legal health record not technically include the metadata as part of that. It doesn't mean you may not down the road, if you're involved in litigation, have to produce the metadata from a chart, but you want to make sure it's not part of your official original legal health record documentation. Those of you on paper charts, or those of you who've been practicing for 20 plus years like I have, would know what I'm saying when I refer to the left side of the chart. Paper charts used to always have all the correspondence and miscellaneous type things on the left side with the actual chart itself on the right. So any of your correspondence for requests for records, production, those types of things are typically not part of the legal health record. I included secondary records on here, but we're going to talk about that in greater detail. I do recommend that you include secondary records as part of your legal health record, and I'll talk to you about why. The important thing with regard to how you handle this on legal health records is that consistency matters, that you have a defined definition, that you apply that definition consistently across your production practices. And then make sure you have training and defined policies about this. The other thing to make sure that it's not part of your legal health record is if you are involved in litigation for a particular patient's care, any of your communications with your counsel or the insurance company related to the litigation or any of the litigation documents, obviously those should not be part of your legal health record. So with all that, if your head's not spinning with all of this, let's talk about a little bit more meat as far as producing records. So where does this come about as far as patient rights? So with the HIPAA and high-tech regulations, everyone certainly knows about breaches and if information is improperly accessed or what we need to do in terms of responding to things and when authorizations are required. But there's also provisions within the High-Tech Act that allows for patient rights that have to be protected. And covered entities can also be responsible and liable for civil damages to the Office of Inspector General for violating these patient rights. So one of those is a request for a copy of their protected health information, which is what we're talking about today on release of records. So patients do have the right to request for a copy of their protected health information, and a covered entity's failure to comply with that request can subject them to civil monetary penalties. For those of you that want a citation of all where these rights come from, they're out of 45 CFR, which is the Code of Federal Regulations, Section 164.522 through .528. The other 4 rights that are part of that is request for correction/amendment of PHI, request for restrictions, request for confidential communications, and request for accounting of disclosures. I'm not going to get into these in too much detail because it's beyond the scope of what we're going to cover today, but we're really going to focus on requests for copies of protected health information. I also recommend as part of your compliance manual that you put together policies for ensuring all of these patient rights are upheld, that you use forms and have form letters in place so that you have consistency. So let's talk a little bit more about a request for copy of PHI and that patient's right. So the easiest and probably the most common way that you're going to be getting a request for records is when an authorization comes in. So I would recommend that you have a standardized authorization form. In the medical malpractice defense work that I do in working with the paralegals at our office, obviously when a patient files a lawsuit against one of my hospitals or my physician, I'm going to be following up to obtain medical records on that patient from their primary care provider and any other physicians that they may have seen either prior to the incident at issue and certainly subsequent to that to gather better information about the scope of the injuries and the patient's healthcare status. So what I recommend to my paralegal when she's working on getting all of those documentation is to the extent she can use that medical practice or that hospital's standardized authorization, it's going to make it that much more simple for that practice to process the authorization. So a good practice pointer would be for your organization to develop a standardized authorization for release of medical information and have that available on your website under a Request for Records tab that provides some instructions to people that are looking to obtain a copy of their records, whether it's patients or even attorneys or healthcare providers or insurance organizations that want to get copies of those. To the extent they use your authorization, which you know has been approved and is in compliance with the HIPAA and high-tech provisions, it makes it easier for you to go through that. The core elements of what is required for a valid authorization under HIPAA is set forth there at 45 CFR 164.508. So a valid authorization must have a description of the information to be used or disclosed. So typically this will say any and all records, but it could be more specific. Some plaintiffs' lawyers don't like to get the entire chart because it can be costly, and they may just ask for certain parts of the chart. So there needs to be a description of what needs to be obtained. The name or the identity of the person or class authorized to make the requested use or disclosure, so it needs to be identified to your organization. It has to have the name or the identity to whom the disclosure is to be made. If this is being made by a law firm, typically we'll have the law firm's name and may have the name of the requesting attorney or paralegal, but you typically will have the actual firm's name to give them authorization. Description of the purpose of the disclosure. This typically may just say something for litigation purposes or for subsequent care. It just needs to make sure it has a description. there needs to be an expiration date or an event. So this is important because the patient has to have put in a time frame of how long this authorization is valid for. It could be for 1 year, it could be for 3 years, it could be for 5 years. As long as it has a defined date, that's going to be okay. It also can have a defined event, such as until my death. There has to be the signature of the individual and the date, and there also needs to be, if that individual is not signing, the relation if it's a representative. For instance, if you have a minor and you have a parent that is signing on their behalf, or if you have somebody who is disabled, you have a guardian signing on their behalf, or if you have a deceased individual and you have a personal representative that's signing on their behalf. There also needs to be included a statement that the patient has a right to revoke this authorization at any time. There also has to be statements that the care cannot be conditioned on execution of this. There has to be a statement regarding potential redisclosure of the information. So what I recommend is that you use some checklists. And I believe that Don Mills sent out ahead of time one of the attachments should be an authorization checklist with some required elements. This is kind of a standard template that I've put together, but you certainly can adopt this for your organization. But it's got a checklist of 14 different things for you to go through. And it's in compliance with that section of the HIPAA regulations for your staff when they're analyzing a signed authorization coming in that's been completed by a patient to make sure that all those core elements have been completed. And there's also some descriptions in each of those that you can look through on your own time. I also recommend that you use policies for frequent issues that may be coming up and also for complex ones. If you're dealing with psychotherapy notes, HIV status, drug and alcohol, remember that there are more specific heightened standards and statutes, both state and federal, that would apply to the release of those information. And I'm not going to get into the details of that, but if you want to have that, you can follow up with me offline. But make sure that you've got some policies to make sure you're being consistent on how you're handling those things. Some of those require specific court orders. Some of those require specific separate authorizations that cannot be combined with a general authorization. So a couple practical tips on this before we move on to the next area is, like I said earlier, with secondary records. So what this is, for instance, let's assume you are a primary care practice. And as part of that, your physician obtains a copy of the documentation and records from a cardiologist that he had referred the patient off to. So he then gets the progress notes from that cardiologist. Your physician will typically review those records and may even initial and date those records, or if they're electronic, we'll be clicking on those and looking at them once they're scanned into the chart. Those then become part of your legal health record because they're part of the decision-making and medical process that the physician has gone through. So based upon the high-tech regulations that went into effect in 2013, those secondary records are now part of your actual chart. That's one of the things we see in the litigation realm is we get some pushback from providers at times where they don't want to provide a copy of those secondary records because they don't feel that they can certify that they are true and accurate copies. Well, what you're doing when you're including those secondary records in the production of your legal health record is to show what was actually obtained and is part of your record that was part of the treatment decisions made by the practitioner. So you want to make sure that you're including all of those secondary records. As an attorney, when I'm requesting those records, I want to know what that primary care physician was provided with as far as information from that cardiologist. What information did he have in the chart for consideration when making the next step in the next treatment decision? Another tip or problem area that comes up is when you have an authorization that the patient has only limited to specific body parts, such as any care related to the head when you've got somebody who may have fallen and has a brain injury. And they don't want to have anything else released regarding other portions of their body. This can be very difficult for practices to try to comply with that because it may require you to have somebody in your office sit down and go through the chart and try to figure out what portion of the records pertain only to the head versus the other part. So a lot of practices will send back a denial letter to say that they require a full authorization for the full body. Otherwise, they may set up a practice where they're going to require that they be paid for the time and having somebody go through the chart to try to determine that. What my recommendation would be is to try to work with the requester, whether that's an attorney or a insurance company that's trying to get the records. If there is some type of limitations on the authorization, try to work with that requester to see if you can work things out, and try not to be overly difficult. If you do, that often results in a subpoena being sent and depositions and less compromise. So pay attention to those things. They can be sticky. The other practice and tip pointer would be to the extent you have an authorization coming in with a request for records and there is some problems or concerns with the authorization or in complying with it, if you're doing anything other than sending out the certified records, in that response letter, make sure that you communicate what deficiencies there are with that particular authorization so that the recipient and the requester can try to clarify those things and correct it. If you have electronic medical records and you're going to be making the production by a CD or a thumb drive as opposed to sending out paper records, I do recommend that you encrypt those devices. They're easy to be lost, and you want to make sure that that information doesn't get into the wrong hands. And then you can develop a policy of how you want to send out either a separate correspondence, email, or fax with a password to decrypt that information. So if you don't receive an authorization where the patient has authorized the records to be produced, a second method of how you may be getting a request for records is a subpoena. This often comes with a notice of deposition, and the subpoenas are sometimes referred to as a ducis tecum, which means they're asking you to bring the documents with you to the deposition. It's important that you make sure you review the scope of the subpoena and what records are being requested, that there's some clarity as far as any dates or those limitations on body parts, the scope of the chart. The subpoena itself, as well as the notice of deposition, should include a location for the deposition. If, in fact, the attorney has notice of deposition to take place at their law office as opposed to at your medical practice, a lot of times you can call the attorney to try to work that out and see if they'll agree to come to you. If they're going to insist on a subpoena and sending it to you and forcing you to come to their office, the regulations do provide that you are entitled to be paid a witness fee as well as the mileage for your round-trip travel from your practice to their office, as well as being paid the fee for the copy charges. If you do have to travel, you want to make sure you do not take the original chart out of the office, that you're only bringing a certified copy of it to the deposition. The witness fees are set out by statute, and I think I do have that a couple pages later. So the question is whether or not to attend the deposition or not. The general recommendations I have is that you should, if you're served with a subpoena with a notice of deposition, you should plan to attend the deposition unless you can speak to the attorney for the patient and they have agreed to producing the records in lieu of going forward with the deposition, and you have that agreement written and in writing and in the chart. Absent that agreement, you need to go forward with the deposition because that is the time that the patient's attorney can raise any objections that they have to your organization producing the records. Just because you get a subpoena does not mean that you give the records without an authorization or a court order. So if you do get a subpoena, make sure that you plan to attend the deposition. The other thing that you want to make sure you do is written consent to produce records in lieu of deposition. Like I said, sometimes attorneys will send a cover letter with a subpoena and the notice of deposition that says, in lieu of proceeding with the deposition, you can produce the records. Once again, don't do this unless you have the written consent of the patient's attorney. Once that bell is rung, it's hard to unring it. So make sure you've got all of that documented and kept within the chart. Somebody had asked by email whether or not I've got a copy of a medical authorization release form that I can share. Yes, I'd be happy to. At the end of the presentation, you'll find my email address. If you want to shoot me a quick email, I'd be happy to send off a sample template to you. The other thing you want to make sure you're doing with regard to subpoenas is that you're also doing some internal auditing and quality checking in responding to these subpoenas before you bring the records to a deposition or in response to a subpoena. Make sure, once again, that there are no errant records of other patients in those. When we get records in on litigated cases and my paralegal is going through those, we often will find where a medical provider has inadvertently included a couple pages from another patient's chart. It just got misfiled. But we try to make sure, obviously, we pull those out before we then produce the records further in the course of the litigation. But we always do try to call the provider up to let them know that we got something in error. So to the extent you can prevent that, that certainly is going to put you in a better position. If you do have to go forward with a custodian of records deposition, a couple things to give you some background on why these may go forward. And the attorneys that are sending off the subpoena with a notice of deposition may want to go forward with a deposition as opposed to just getting the records. So the reason why they may want to go forward with a custodian of records deposition is to authenticate the records for admission at trial. So there are statutes in Missouri and Illinois that establish the evidentiary foundation for business records, and by getting that deposition at from the custodian of records, we then can get those records admitted into evidence. The thing that's important is to make sure that in terms of authenticating the actual records, if you're providing a copy of the chart with an affidavit, that affidavit needs to be signed by a representative of the medical practice itself, the covered entity, not the vendor copying service if you're using them. Another purpose of the custodian of records deposition is to identify the types of records that are maintained. So to find out some information about, do you have hard files, do you have telephone messages, internal memorandums, emails, faxes, that type of thing. If in fact that becomes an issue in a case where they want to know, did Dr. Jones speak with Dr. Smith, and is there a telephone log, and there's nothing in the chart that reflects any of that, a custodian of records deposition may try to find out more about that process. You also can learn about the entity's records filing system, identify the location of all records that are maintained, identify media storage of the records, learn of any destruction policies, learn who is in charge of maintaining the records and are there sub-departments, learn of other witnesses or facts you need to prove or defend your case, if there's any missing records or incomplete production. But typically these custodian of records depositions are not for substantive care issues, but rather process. So your person who's going to be responding and appearing at a custodian of records deposition needs to be the one that is familiar with the documentation system at your practice, how records are generated and what is completed. I'll give you an example of a custodian of records deposition I took not too long ago on an OB malpractice case. There is a private OB who was doing some of the prenatal care, but then the patient appeared at the hospital for delivery that was handled by another OB. And so we took a custodian of records deposition of the private OB's office to find out whether or not the patient had actually been scheduled for a C-section as she claimed. And so part of why I deposed the custodian was to learn the practice and the policies of how they do their documentation. If that patient had officially been scheduled, what type of paperwork is generated and would that be part of the record? So it's more of that process as opposed to the true care issues. So there could be a reason why an attorney wants to go forward with that deposition. So make sure you have somebody who's knowledgeable that's going to be responding to that custodian of records deposition notice and subpoena. This is the rule in Missouri. It's Rule 57.03 that sets out the location, date, and time and the manner of reporting that needs to be part of the deposition notice. You are entitled to 7 days notice. So if they send you a subpoena with a notice of deposition that is not giving you 7 days, that is deficient, and you can call them up and tell them you're not going to appear because it's not valid. Be careful about communications in advance. So if you receive a custodian of depositions notice and subpoena, you are permitted to have contact with the attorney's office that's issuing that subpoena, assuming they're on the defense side, not the patient's attorney, for scheduling type things. But that defense lawyer should not be calling and talking with your nurses or doctors substantively about the care. There's a rule called Proctor in Missouri and a Petrillo in Illinois. So scheduling issues are okay, but don't get into substantive discussions outside of the actual deposition. Like I said, you should have subpoena ducis tecum, that is to produce the records. It should specify what needs to be produced. Can't avoid requests for production timing for parties by doing this. That's more of a litigation aspect. There typically is a cover letter that will explain some things. Look for your witness fee and mileage if those are applicable if you're being asked to travel. Copying costs, which we're going to talk about, and be careful about discussing that care. So with regard to release of records, as you've probably figured out by now, a patient is permitted to obtain a copy of the record. They technically own the information that's part of it. Your covered entity is responsible for maintaining the records, but the information belongs to the patient. There are a few limited exceptions of things that patients are not permitted to get, typically psychotherapy notes. If you represent mental health providers, that can get a little complex and you may need a little bit more detailed guidance on this, but psychotherapy notes and testing typically can be withheld from particular patients because those can cause irreparable harm if in the impression of the psychiatrist they should not be produced. And then there's also provisions that allow medical providers not to release certain aspects if there is harm to the patient. So, all right, so let's look at some of the law on this. So in Missouri, this is the statute that talks about medical records being released to patients. The key things I wanted you to see with this, and I've provided you with an actual handout that has the full statute, but I've copied it here on the slide. This is what sets out the fees that can be charged for you to have to provide a copy of the records. So as you go through this, it talks about physicians, chiropractors, hospitals, dentists, other duly licensed practitioners, they're all providers, shall, upon written request of a patient or guardian or legal authorized representative of the patient, so that's where your attorneys can come in, furnish a copy of the record of their history in response to a written request, and then it's limited to access consistent with the patient's condition. So that's that limitation I was talking about. And here is the part that talks about the retrieval and copy fees that can be charged. So if you have paper records, this is a statutory provision, and the dollar amounts on this were updated, which you'll see in the next couple slides. But by statute, you're allowed to charge search and retrieval fees in an amount not more than $24.85. So that's your flat retrieval fee, plus copying in the amount of 57 cents per page for the cost of supplies and labor plus. And if you have an off-site storage location, so you have the shed that has all the records out there and you have to have somebody go and pull those records out of storage for you, you can pass on that additional labor cost and the outside storage retrieval fees, not to exceed $23.26 for that. And that amount is updated annually. If your organization maintains electronic records, you are to furnish electronic records with a payment of $108.88. Total is the max. So you can charge the retrieval and handling fee as well as the per page amount, but if it exceeds $108.88, that's the max that you can charge. Whether you have paper or electronic fees, or paper or electronic files, excuse me, in addition to the retrieval fee as well as the per page, you also can charge for postage, including packing and delivery costs. So if you use FedEx or UPS to send out your documents, or even just the United States Postal Service, whatever the direct postal charge is for that, that can be charged on to the requester. And then if they have requested notarized records or authenticated records, you can charge a notary fee not to exceed $2 on top of that. The statute also provides that if requested for an affidavit to be completed, you should be completing that and you need to respond within 30 days. Some other nuances of the Missouri statute is for the purposes of those first two sections, where it talks about a copy of his or her record of that patient's health history and treatment rendered, or their health care records. This is going to include a statement if you're sending out a response to say, we don't have any records for this patient. So if you get a request for patient John Smith and you don't have anything, you can charge the retrieval and per page fee to draft that response letter saying we don't have anything. Some providers do this, some don't, but technically you can rely upon this provision within the regulations to do that. The second part here, number 4, talks about providers can charge for reasonable cost of duplications of healthcare record material or information which cannot routinely be copied or duplicated on a standard commercial photocopy machine. So if in fact you have old microfiche, I know we're really getting into some old stuff here, documents that have to be downloaded and it's going to cost you additional expense to try to get those printed up or reproduced, or same thing with x-rays or any type of imaging studies, you can charge a reasonable additional fee for that. 5 is your immunity provisions. The transfer of patient's record done in good faith shall not render the provider liable to the patient or any other person for any consequences which resulted or may result from disclosure of the patient's record as required by this section. So this is where having your policies and procedures documented that provide some guidance on how your practice responds to requests for records. And if you're in compliance with those policies and acting in good faith, it's going to help provide you with some immunity from any potential civil lawsuits. And then there's also some provisions with regard to deceased patient records. Under the new HITECH Act, once a patient has been deceased for 50 years, their records are now available, which is a little rarely known fact that people don't really know about. So let's talk about those fees. So the statute, as we just read, provides that it is to be updated annually for inflation. So the current fees in effect that were effective as of February 1st of 2018, so the beginning of last year, has that currently the retrieval fee is $25.51, and this is, you have those paper fees at 59 cents per page for the cost of labor, and then $23.88 if the records are maintained off-site. The new maximum fees for electronic records is $25.51 plus 59 cents per page, and on $111.79 is the max total if they're provided electronically. So somebody had sent in a question and said, and if an insurance carrier requests multiple charts, can you charge the amounts per chart, or is that total? I don't know if I've ever been asked that question. I would assume you're able to do it per chart. But I'll look into that one. If you want to send me a separate email, I'll get back to you on that one. So let's look at a couple of these. First of all, this is the fees here put in just a little bit better form instead of having it in the statutory. So once again, if you have paper records, you're allowed to charge $25.51 retrieval fee, then 59 cents per page of the records, and if you have an outside retrieval storage company, $23.88. And then obviously you can do your postage notary. If you have electronic records, it's $25.51 retrieval fee, 59 cents per page, but that is capped out at $111.79, whichever is less. So let's look at a couple examples that may help us flow through this. So you're a practice that has a chart that is stored on-site in paper form, and it's 120 pages in total, and your staff does the copying. So you do not have an outside vendor company. You don't have to go out to the shed to locate it. It's all located right there in the office. You can charge the $25.51 retrieval fee. The 120 pages at 59 cents is an additional $70.80. Your postage you have weighed, and it's going to be $4.35, a $2 notary fee, so $102.66 is the amount that you can charge for those records. You can send out a prepayment request prior to the records being sent out. Once you get paid your $102.66, you can send those records out. Another practice has records, but they're entirely online. They use an EMR system, and the patient requests a CD of the records. There's 250 pages. Once again, you can charge the $25.51 search and retrieval fee. Actually, it should be more. Instead of 120 pages at 59 cents, it should be 250 pages at 59 cents. So that's going to more than double that. Your postage is $4.35. Notary is $2. So actually, this is going to be well over to $179. It's probably going to be closer to $300 and some dollars. But recall, under that statute, it's maxed out at $111.79. So even though I screwed up on my math here, you're still going to be limited to this max of $111.79. So with your electronic records, the voluminous number of those pages is not going to drive up that production cost just because you're typically putting those onto a CD. So moving on to The other thing real quick, let me back up real quick, is with regard to these charges, if you looked back at my slide here from the date on this, it was February 1st of 2018. It is updated annually at that time. So here in about 3 weeks on February 1st of 2019, we're going to get another inflationary adjustment to those amounts. So be on the lookout for that because that's likely going to go up a little bit. So some general record-keeping risk management tips that I have, and this is coming from litigation as well as transactional experience, but what if your medical records are released without a valid authorization? And you can imagine from the things I've been discussing, there's both criminal liability as well as civil liability that can flow from that. Criminal, typically it's a Class A misdemeanor, and this is for somebody who uses willful or wanton means in the course of action that shows actual or deliberate intention to cause harm. So if you have some rogue employees that are producing things without any type of compliance and responding to requests without any type of guidance, it is potential for criminal liability. This is likely not going to happen, but to the extent you've got written compliance plans, it can certainly help mitigate that liability. What's more likely is potential civil liability, and what's important for this is that an organization can be held responsible civilly and therefore monetarily if medical records are released without a valid authorization or in accordance with law. So it's important for you to have a compliance plan that complies with both HIPAA and HITECH. And the individuals can be liable, not just the organization. Sometimes there is not insurance coverage that would cover this unless you have breach or cyber liability insurance, and it also can cause licensure problems for your practitioners, your providers, if it gets to that level. So just some things about why this is important. Not going to go into examples on the fines, but obviously the fines can be $100 per record up to $50,000 per disclosure, up to $1.5 million per category, and there's 4 different categories. So if you've seen some breach violations out there in the news, that's what's been driving all of this. So I often get asked questions about what if a patient's name is redacted. So sometimes attorneys will try to get records on another patient who may have been in the office at the time, or they want to have records of similar patients with similar diagnoses so they can look at things. And they suggest that if a patient's name is redacted, that that's okay to produce the record. As I said earlier, the information in the medical record is the property of the patient. Merely deleting the patient's name and identifying numbers is not sufficient to uphold a patient's expectation of privacy. And even with deletion of the identifying numbers and names, a patient confidentiality is still compromised. There are 18 identifiers under the HIPAA regulations that have to be removed for something to be considered de-identified, for it no longer to be PHI. So be careful if you ever get requests where they say you can just black out the names. That's not going to be sufficient. As I mentioned, there's employer liability for employees' negligence in wrongfully releasing medical records or wrongfully accessing them. So be careful of rogue employees that go snooping or produce records that they shouldn't. That's both the employer and employee that can be liable for that. You need to make sure they're acting within the scope of their employment. Obviously, you don't want it to be criminal conduct, but this is where training is critical for you to make sure your employees know what they should and shouldn't be doing and that you have documentation of that. On the employee side of it, the HITECH provisions now provide that employees themselves can be individually liable, so it's important you make sure you train your staff. All of your employees hopefully are signing HIPAA policy acknowledgement forms, which indicate that they agree to be bound by the practices, HIPAA privacy and security provisions, as well as the HIPAA and HITECH regulations. Having that documentation will help you in the event of liability from a potential employee that does something, and you want to make sure you've got all of this documented within your compliance manual. I've provided some information on some jury verdicts out here just to give you some idea. I think there typically is this misnomer or misconception that there is no private cause of action under HIPAA and therefore nobody can be liable for a violation of privacy or wrongful disclosure, and that is not the case. It's not under HIPAA, but there are state law invasion of privacy or wrongful disclosure provisions that have been upheld. So this is just a couple verdicts. Some of these are a little bit older, but they're still valid for you to at least have some information and some background. So the first is this Austin case, which is a 23-year-old woman requested the medical records regarding the birth of her child and an impending adoption be confidential. So she was pregnant. delivered the baby, but she told her mother that she had lost the baby. Her mom then obtained the records without the patient's consent. She sent in an authorization, and the practice sent the records in response. And the mother then confronted the patient after being told that the baby had died, and it resulted in a $334,000 verdict. So the tip is to make sure you have good protocols for release of records and restrictions on confidential communication. So if a patient tells you they only want information sent to certain addresses or certain phone numbers, make sure you have protocols in place to comply with that. Another one is the Raymond Hicks case. This is a physician who underwent some alcohol rehabilitation and had to submit proof to a state licensing board that he was making progress. As part of the documents that were produced, it included his sexuality, the fact that he was a homosexual, and that got disclosed out and produced and caused some harm. So make sure the tip from this is that you look at the scope of the information that needs to be released. They produce records beyond the scope. The Williams case has to deal with a physician who was accessing medical records of his ex-wife's current spouse. The jury in this case awarded a verdict of $381,000. It was being accessed to be used against the spouse in a custody dispute. So the tip with this is to realize that there are audit trails out there, so your staff need to be trained not only on what they access and what is being produced, and so making sure you've got good documentation of that. And that includes your physicians, no snooping. A case that's a little bit closer to home, this is an oldie but a goodie, the Fairstein case against DePaul Health Center in Missouri of 1999. Medical records were released without the proper consent. This is a situation where the attorney sent the request for records and said the records could be produced in lieu of going forward with the deposition. The practice, or DePaul, did not confirm with the patient's attorney that there was no objection to that and went ahead and just produced the records. So this is a very instrumental case that establishes that practice of making sure you go forward with the deposition unless you receive in writing that the patient agrees through their attorney to produce the records. I'm going to skip through a couple of these. You have the handouts that'll give you some more details on it, but they just highlight some of the nuances in the verdicts that have been coming out of these things. A couple tips I wanted to point out with regard to statutory retention requirements. Under Missouri, you have to make sure you're maintaining your medical records from 7 years from the date of the last contact with the patient. If there is anticipated or pending litigation, you want to make sure you're maintaining those records longer so that you put a litigation hold on that chart. With regard to minors or disabled adults, you need to make sure you have those records for 10 years, and it takes into account possible extensions to the statute of limitations for minors. So if you've got a minor, they typically have until the age of 18 plus 4 years to file that lawsuit. So those records need to be kept a little bit longer. This is the website for the American Health Information Management Association retention guidelines that a lot of you likely know about, but that has some good other tips. Some quick things, and I know we're getting close on time here, is with regard to ongoing litigation or investigation. If you do have a case that's been, a lawsuit has been filed and you've got the case involved in litigation, you want to make sure you're securing the medical record, so locking that down so nobody can go in and change a paper record, or if it's an electronic record, to work with your EMR vendor to secure that down so nothing gets changed. Be careful about accessing it even after the lawsuit has been filed, because you're going to be generating an audit trail in there. Also, don't forget about x-rays or other type of other media that you may need to secure, and other documents such as fetal monitor strips if you're an OB, or any other type of ancillary testing that may be done that has generated its own information. Once again, limit the access and keep a log of who is accessing that chart. Why all this is important, and I've provided some case law here, is the practice can be subject to negligent spoliation of evidence claims. So if, in fact, a lawsuit is filed and you have not maintained the medical record or lost a fetal monitor strip on an OB case, that can lead to some adverse inferences where the jury can infer that that information would have been damning for you. So it's important from a liability standpoint to make sure that you're maintaining that. Here are some sites of some cases in Illinois as well as Missouri, and some examples of where we have seen these type of spoliation of evidence claims. So EKGs, cardiac strips are lost, fetal monitor strips, x-rays, those type of things. Destruction of paper health information. Be careful about what you do when you are destroying your records, when you're past that retention time frame and you're going to get rid of those. Beware of dumpster divers. If you ever want to Google just CVS and Rite Aid, they got hit with some pretty expensive breach claims for throwing things out in the dumpster out back. Some guidelines here on destroying the records only after expiration of the retention period. Approved methods of destruction. Make sure you've got log books that document your destruction. Have certificates. If you're going to contract out with a provider to do this, which I recommend you do, use a BAA, and it certainly is more complicated with the EMRs. Last couple things, safekeeping guidelines. Develop written policies for all of this. I know this can be very complicated. Make sure you're developing some written policies on all of this to help guide it so that you can fall back on those. Do not ever release original records, specimens, or radiology films without a court order and a chain of custody. You want to make sure you've got a sign-in, sign-out procedure for original records if you still have papers. Secure access and passwords. Legal lockup. Make sure you've got a policy if there's a lawsuit. Follow your retention and destruction policies, and most importantly, develop a HIPAA privacy and security compliance plan that kind of guidelines all of this. I'm going to jump ahead of this with regard to medical records in the courtroom, but here's some fun things I thought that you see from one of my cases. These are the progress notes. These get a little hard to read, don't they? So make sure your practitioners are trying to make things legible. And this is the evolution of handwriting, to finish off with a little bit of humor. So in college, you start out with this nice, pretty, easy writing of the quick brown fox jumps over the lazy dog. Medical school, it then goes into the quick, and you're highlighting everything. The quick brown fox jumps over lazy dog. Residency, you can see that the writing is getting a little bit more difficult to read with the sleep deprivation, and you've got all of your documentation there. And then for the attending, they typically just write it out and say, see the resident's note. So the evolution of medical documentation. And with that, I think I'll turn it back over to Greg.
Hello, everyone. Greg Thompson, President of Greater St. Louis MGMA. I think Diane has addressed most of the questions, except for one that came across a few minutes ago, which I myself have had this come up as well, where attorneys come back and say, well, the federal laws supersede Missouri, and this is $6.50 maximum we can charge for patient release of information. Is that true?
And it's funny that you brought that up, because I was just actually talking with one of my colleagues about that yesterday. The state law provisions, Missouri provisions, are more specific on that than the federal law. So my recommendation is that you are in compliance by using the Missouri statutes on that. The HIPAA regulations provide for the ability to charge, but the state law sets out the actual details on it. So I know there is some particular lawyers that say $6.50 is the max. I think you're on solid ground to say this is our policy, this is what the Missouri regulations provide, and you can charge the statutory amount under Missouri. So if you want to contact me offline, I'd be happy to work with you on it some more. Like I said, I've got one of my colleagues that just talked to me about this yesterday, and I'm wondering if it's one of the same attorneys, because I think he's pretty aggressive. So.
Yeah, I got a letter from one that was like 12 pages long of all the statutes and everything that he was quoting, saying
right.
That we were all, he's going to turn us into OIG if we didn't comply and all that kind of stuff. So.
We've got good contact with the OIG, so we're happy to go right back at them. My contact information is on the bottom of the slide. If you want to shoot me any questions, I'd be more than happy to answer them. I know that I try to cram a lot of information in an hour, and hopefully it was helpful for everybody.
Thank you, Diana. Thank you, everyone, for joining us. Before you go, I'd like to remind you that registration is now open for the Medicare update in February in Orlando's. We hope to see you there. Thank you, and have a great rest of your day.
Thank you.